G'day everyone, and welcome to the third video for week 2 of our admin law course. So far in week 2, we've learned how some courts and tribunals get their power to review administrative decisions. We've learned that they can review decisions of an administrative nature made under an enactment. In the second video, we broke that down and learned that a decision for the purpose of administrative law includes an actual decision, conduct related to making a decision, and the failure to make a decision within a reasonable time. In this video, we're going on to ask what is meant by a decision of an administrative nature. Now, you'll be pleased to know that some of this material overlaps with the concepts you've already met in the second video. For instance, in that video, we learned that the prerogative decisions, such as the prerogative power of mercy and pardon, are not decisions of an administrative nature. We also learned that rule-making is not a decision of an administrative nature. Let's develop all of this. I want to start with the separation of powers. You remember we talked about that last week. If you didn't happen to see that video, now would be a great time to hit pause and go back and have a look. In that video, we discussed the concept of the three estates of power. There is legislative power, judicial power, and executive or administrative power. They are separate types of power. It therefore makes sense that there are going to be legislative decisions using legislative power, judicial decisions using judicial power, and administrative decisions using executive power. It therefore also makes sense that legislative decisions and judicial decisions are not decisions of an administrative nature. They rely on entirely different types of power. Let's start with legislative power. Now, we peeked at this in the second video when we talked about rulemaking. The principle is that a decision is legislative in nature if it establishes a rule of general application, but it's administrative in nature if it applies that rule to a particular case. Now, that sounds simple enough, but the boundary between the two can sometimes be really complex to identify, particularly when it looks like a new rule is being established in response to an individual case. In fact, as recently as 2016, in a case called Jagroup against the Minister for Immigration, two judges of the federal court described the distinction as difficult in theory and impossible in practice. In a case called Roche Products and the National Drugs and Poisons Schedule Committee, the federal court set out some indicators of a decision with legislative characteristics. They included general applicability, which we've discussed, public consultation in the making of the decision, consideration of public policy issues, which means the decision maker considering what's in the public interest rather than just considering fairness to the applicant, and a requirement that new rules be published in the Government Gazette. Now, it's really important to understand these are not just elements you can simply apply. They're just indicators. So each time you consider whether a decision can be reviewed, you should consider whether it's actually rulemaking. Next, let's think about judicial decision-making. Judicial decision-making, it should come as no surprise, involves a judge considering a dispute, resolving questions of fact and law and pronouncing a judgment. Now, obviously, when a judge does this, it's pretty clearly judicial decision-making. But remember, Australia does not have true separation of powers. Sometimes public servants, who are executive officers, make decisions which are very similar to judicial decisions. For instance, if two parents are in dispute about the payment of child support, the Child Support Agency will make a decision. Now, you tell me, are they acting administratively or judicially? They're certainly public servants implementing a piece of legislation, but they're also resolving questions of law and fact to determine a dispute between the two parties. Many courts have registrars who are not judges, but who make decisions on behalf of judges. This can be really complicated. In a case called Lamb and Moss, a doctor had been charged with fraud and the case was before a magistrate for committal. If you haven't done criminal law, committal is a process where a magistrate determines if the prosecution case is prima facie strong enough for the trial to take place. There was a procedural challenge to the way the magistrate conducted the committal, and the full court found that the magistrate's decision was administrative in nature. This is a decision made by a magistrate in a court during a contested hearing. I would have thought it was judicial for sure, but the court said no. In Luton and Lascelles, the plaintiff challenged what was then the new process for determining and collecting child support. Specifically, he was challenging a decision by a judicial registrar, who's an officer of the court but not a judge. The court found that the decisions of the registrar were administrative, even though they had many of the characteristics of a judicial decision. Chief Justice Gleeson set out a couple of additional factors that can help us to distinguish between judicial and administrative decision making. First, he said that judicial decision making declares rights which were already in place, whereas administrative decision making often creates new rights. That's a pretty cool way to look at it. If I'm suing someone for the payment of money, they already owe me. I'm just trying to enforce my right, so it's judicial. But if I apply for a government allowance, I have no right to the money until that decision is made. So the decision creates a new right. Judicial decisions enforce pre-existing rights. Administrative decisions create new rights. Second, Justice Gleeson said a court can enforce its own decisions. A court can issue a warrant and give effect to its decisions. An administrator can't do that. For an administrative decision to be executed, they would need to seek the court's involvement. So what I mean by this is, if an administrator says that you owe the government department $5,000 and you disagree, the administrators can't just issue a warrant. They'd need to sue you. Chief Justice Gleeson said that a decision maker who cannot enforce their own decisions is more likely to be administrative than judicial. Again though, all of these are just indicators. So when your client has a decision or conduct or failure to make a decision, you then need to ask whether the decision is of an administrative character. So you ask, is it legislative? Are they making rules of general application for the benefit of public policy? And you ask, is it judicial? Are they determining questions of fact and law to resolve a dispute? If it's not legislative or judicial, then you ask, is it prerogative? If your decision survives all of these tests, then you most likely do have a decision of an administrative character. So then we go on to our final test, which is whether the decision is made under an enactment. We'll look at that in the fourth and final video for this week. Before we go though, I reckon some of your heads are probably spinning at this point, because I've just told you that legislative decisions aren't reviewable, but I've said that it's super difficult to tell them apart from administrative decisions. And I've told you that judicial decisions aren't reviewable, but it's super difficult to tell them apart from administrative decisions. I haven't given you any criteria, nothing more than a few indicators. If this comes up in an assessment, then it will be obvious which side of the line the decision falls on. I'm not going to give you a line ball decision and then sit back and laugh while everyone runs around in confusion. But even if you are confused, just telling me that you understand that the decision will be reviewable if it's administrative and not if it's legislative, and maybe telling me a few of the indicators and having a go at applying them, well, that's going to get you a pretty decent mark, even if I think you got the outcome wrong. All right, one more video this week. I'll see you there.